From the Fox 4 studios, you're watching the Evening News.
And it's time again to Ask the Attorney. We're welcoming attorney Gilbert Adams to our show today. His first time being on. He's going to be with us every week, so you'll want to make sure that you get your questions in to our Facebook page and our website. So welcome. We're glad to have you.
Thank you. Glad to be here.
All right, well, let's get to our first question. This one comes to us from Facebook. If a non-custodial parent never exercises visitation sessions and then suddenly decides they want to be a part of the child's life, do you have to force the child to go with them if the child does not want to go?
You know, this goes back to the old adage that two wrongs don't make a right. And you've got to remember, you're under a court order to make your child available to the other parent. So you don't want to run afoul of violating a judge's order and being sanctioned or something. On the other hand, the parent has a concern that the child doesn't want to see the parent. So what I would suggest in this circumstance is to go back in front of the judge and see how the judge would like to implement this process. The judge may want a therapist involved, may want some supervision, and that's the best way to do it as opposed to risk getting in trouble with the court yourself.
All right, our next question. My daughter's father does not pay child support. She doesn't even know him but has his last name. Could I take his rights away? He's also on probation and has been diagnosed as a schizophrenic.
Well, the law in Texas is that you're going to be the parent of your child until a court terminates those rights. And the Texas legislature provides a number of ways in which that can be done. Now, this questioner has raised the point that the other parent hasn't been in his or her life for 12 years. The law is that if a parent abandons the child, and it's got to be found by clear and convincing evidence, but if a parent abandons a child, and that includes being away for 6 months, for not providing adequate support for that child, then yes, the court can terminate those rights. Again, this question raises another concern because the questioner has talked about mental illness. And so a court is going to be less inclined to do that where there's mental illness.
All right, and our last question came from Facebook. It's a long post, but it boils down to this. Someone renting a house says to a friend that a friend took $4,500 worth of firearms from the house without permission. Now he's having trouble getting it back, and he wants to know what his legal options are. Well,
our local law enforcement people are good at what they do. But they're busy. They may have hundreds, if not thousands, of cases. So the statute of limitations in this circumstance is 5 years. So the detective might be having trouble getting a hold of the complainant. What I would suggest you do is place a call every month or so to the detective and ask if you can provide any additional information, or you want to check the status. And again, 5 years, they may be working on other cases. It'll get done.
All right, thank you.
Thank you.
And we are answering your questions every Wednesday. You can go to our website. You can also ask us your questions on our Facebook page. And stay with us. We're back in just a moment.